not unusual. So, I mean, that's something you will have to face.
And I guess then my question is, what is the purpose of Michael Gray's letter when he tells you that that's a potential problem? Is that to me or is that to you?
Well, if you're aware of, if you're aware of the prior application, you could have taken action on all of these objections. And since then, even upon notice of that application. So these things were out there for your concern for quite a long time. So even if you only learned about it recently, there were other avenues you could have taken to address that, looking for a continuance on this so you could seek those avenues.
Okay. I understand that. Not necessarily. You know what? I suggest to you that the lot, which is less than 5,200 square feet, is actually too small to build a house on. But I also suggest, as I understand the process, that a house will be built there. So with that in mind, I think that this is the best option that there is for that lot. And I appreciate your consideration of coming in.
Well, I would have one question, that is, the objector raised the question of whether the house can be placed on the lot so that you have greater space between his lot and the house of 10 feet. Is that possible, or is it laid out in such a way that we will not accommodate that?
When we spoke, we were going off the, excuse me, we were going off the basis that we were going to apply the R20 as some kind of rational dimensions. And then Jack advised later today that there was that deed restriction. So that's, we were going off, when we were putting the thing together, we're working off of the zoning regulations as opposed to the deed restriction. Jack can probably speak to that better than I can.
Well, I don't think we're going to engage in a legal debate about the deed restriction. Well, my question is, would you have the opportunity for the deed restriction to move the house farther away from the lot line?
Yes, that's my understanding. And we have no objection to moving it but for the deed restriction.
I think your counsel said that the deed restriction was going to be enforced by you.
Well, that was with regard to the one bedroom, with regard to the 20-foot on the street. That's different.
Setback.
That's correct.
Counsel, do you have thoughts on this?
Mr. Chairman, I haven't reviewed the title work relating to the property. It's not part of my office's review, and no information is in my packet on it, so I really cannot render an opinion.
I think what we're talking about is the setback issue.
My understanding from Mr. Revens is that there's a deed restriction relating to an 1890 deed or whatever you said regarding a setback.
That's correct. I gave you, I believe, Mr. Chairman, at the beginning of the hearing, a copy of that deed.
Yeah, I had a copy of the deed, but I guess I'm a little confused as to whether that the location of the house
Yes.
is restricted. The question the judge was asking is, can the house be moved farther away from the lot line? And when the response I'm getting from the applicant is that it could, but for the deed restriction.
That's correct.
Is it the deed restriction that's the problem, or the zoning setback?
No,
It's the deed restriction. What my client did before he knew about the deed restriction was he read the ordinance and then went to the R20 setback standards, which is where he got the 20 feet from as a requirement. When we looked at the deed in preparation for zoning, and I don't often spend a lot of time looking at deeds in preparation for zoning because you don't typically run into these kinds of things, except in a situation like this. When we looked at it, when we saw it was 20 feet, we said, well, it's okay because we've got 20 feet. Then, when the neighbor contacted my client and asked if the house could move a little bit farther away from his property, my client had no objection to that. If he wasn't restricted by the deed to move it instead of 10 feet, move it another 4 or 5 feet and make it 15 feet on each side instead of 20 and 10.
We're talking about moving it closer to the New York Avenue?
Yes. But the deed restriction is a problem we can't get around, and unfortunately, I wish I could stand here and say that you have the authority to override that deed restriction as members of the zoning board, because if you had that authority and you asked us to agree to it and move it a few feet the other way, my client would be willing to do that, but I don't think as the zoning board you can make a decision that would override the deed restriction. My concern would be if my client or a subsequent buyer got a mortgage on this property, whether the title company would have a problem issuing the title policy if they discover the deed restriction. If you want me to get an opinion from the title company about that, I can do that.
I don't think it's our role to make that decision or to give an opinion on it, but I just wonder if there's some way that you and the objective to work that out. Well, you can work on that.
Well, if that's the direction that you're giving me, we can work on it. It'll be, as you know, a yes or a no answer based on what the title company tells us. So if the title company tells us that it could be moved, I think my client would be willing to move the house slightly in that direction. And if the title company says that we can't, then it's not because my client's not willing to do it, it's because the law of the deed restriction doesn't allow us to do it. So if you wanted to continue it but close the public hearing, we can get you that answer in writing and we can provide a copy of that to our neighbor. I'm sure we can have it within 2 weeks.
Well, I'm reluctant to keep
So
these things passing along.
I don't have the advertisement in front of me, but does it mention the 20 feet?
My engineer tells me it would have to go 10 feet one way or the other because of the drainage on the site. So if we went and moved it the way the neighbor is asking, we'd have to move it about 10 feet. So we'd have to have 20 on that side and 10 on the other for the drainage to work.
I think that's what he asked for, actually, the neighbor.
Right, if we didn't have a title problem or deed restriction, we could do that and we'd have no objection